Johnson.
Mm.
Good point. Good afternoon, everybody. Today is Tuesday, February 9th. Welcome to the Ways and Means Committee for our hearing. Today, we have 9 bills ahead of us, a mix of tax and election law bills. We are starting with election law, but there's a little bit of back and forth today so as to accommodate the governor's office on the Senate Bill 496. Typically, we take them first, but they did not want to be first. So we will start now with a departmental bill, House Bill 738, and I assume that's why Mr. Demarinis is here.
Yes, thank you, Madam Chair. Jared Demarinis, Director of Candidacy and Campaign Finance for the Maryland State Board of Elections. This bill, House Bill 738, the State Board of Elections supports this legislation, and thank you, Chair, for putting it in for our departmental bill. This legislation is an election calendar correction bill to align certain deadlines with the ballot printing schedule. It alters the deadlines when a successor candidate for a gubernatorial or a lieutenant gubernatorial candidate dies, withdraws, or is disqualified. It basically requires that any possible changes to the ballot begin no later than 70 days prior to the election. And then it changes the deadlines for the selection for the successor candidates by a central committee to file a certificate of candidacy with the State Board of Elections no later than 65 days before the election. The legislation amends the date when, if a gubernatorial candidate or a lieutenant gubernatorial candidate dies, has to remain on the ballot from 15 days to now 69 days prior to the elections. These changes are necessary to avoid ballot production disruption and possible voter confusion because the 15 days is so close to early voting. And this will align with the calendar that we have laid out for ballot production and making sure that there's ample time to get everyone their mail-in ballots as well. Additionally, the bill changes the deadline for ballot summary statements for statewide questions by DLS and approved by the Attorney Generals to be submitted to the State Board from the 4th Monday in August to the 1st Monday in August. This will allow for public display of the complete text of the question at the 65th day rather than the 30th day currently in law. So this will give the public more time to view and understand ballot questions with the summary statements there. And then finally, the bill authorizes the state board or a local board to provide, if requested by an individual, the complete copy, the complete text of all the constitutional amendments and questions electronically rather than just by mail. This is just kind of like modernizing the system there. So that's pretty much it. I believe I've talked to council too. I think there's just one little amendment that when bill drafting's moved over that it didn't make all the dates go to 70, and I'll work with Stan on that one simple little amendment request there. But with that, again, thank you, Chair, for introducing our departmental bill, and I'll be happy to answer any questions.
Sorry about that. Thank you, Mr. Demarinis. Delegate Wilkins.
Thank you so much for bringing this bill and for walking us through that. I was just wondering if you can get a little bit more granular in terms of what this will mean for the candidate and for the voter. So maybe a good example is that recently we did really tragically have the death of a lieutenant of it was a gubernatorial candidate. Yes. But nevertheless, if you can walk us through kind of what this would look like a little bit more in terms of the candidate and for the voter, that would be really helpful. Just make it a little bit more real for me. Sure.
So the Kevin Cabinet's situation was kind of the impetus behind this bill here that you mentioned with this. So at one point here, when he passed away, the lieutenant governor had the ability to move to become the gubernatorial candidate and then select a lieutenant governor candidate. However, the process was already passed when we were mailing out ballots. There was some confusion as to pulling them back And also it was very close to when early voting was beginning at that point there. So in this scenario here, we have made the deadline align with the ballot printing. So, with 45 days outside of the election is when we start mailing out the absentee ballots, but we need to print them beforehand. And that's usually around the 65th day or so to make sure that all the printing is done so that we can hit send on the 45th day. This will align the succession, or if there's any death or withdrawals by a gubernatorial or lieutenant gubernatorial candidate with that. If it falls within the 69th day, then those candidates would remain on the ballot. And then if subsequently elected, then the vacancy process would take place, or the replacement, if it was in the primary, then the replacement would take place because that candidate is no longer eligible or was disqualified due to death for a replacement. So in a sense, it allows, it makes the ballot itself at the 69th day, you'll know exactly how your ballot will appear, what it looks like. If there's any changes inside of that, it will be through public education and then the normal process of it. What happened when we did the cabinet situation was that there was the trying to replace Kamenetz's name on the ballot, having already mailed out mail-in ballots to individuals. So some individuals would have had Kamenetz on one ballot, other individuals would not have had it on there. So this would have caused a little bit of voter confusion, and it's difficult for the candidate who would have been, the successor candidate for that candidacy to kind of say, well, vote for, or if you receive a ballot, vote for this person on that ballot, but if you see my name on this one over here. So this kind of eliminates all that confusion for it and allows us then to say, with a public campaign, vote for X candidate really means, a vote for this candidate, with flyers or with banners out there, but not necessarily changing all the ballots because it would be confusing and cost prohibitive.
Got it. Thank you.
Thank you.
Thank you, Delegate Wilkins. Thank you, Mr. Demarinis. Any other questions? All right, thank you so much, Mr.
Thank you.
You're here on some other bills in case anyone has any questions. Appreciate your excellent testimony. My wife listening in thought everyone should give their testimony like that.
Thank you. I appreciate that.
Explain what the bill does. Very, very, very orderly. Anyway, if seeing no other questions, we're done with the hearing on House Bill 738. And now we begin a Delegate Hornberger Lollapalooza.
Thank you, Madam Chair. And for the record, Delegate Kevin Hornberger on HB 690, the Elections Integrity Act. This bill was actually requested to be cross-filed by Senator Gallion, which is SB 36 in the Senate. And what this bill intends to do is to cut down on ballot harvesting. As you all know, this last election that we had in both the primary and the general, and then also the special election for the congressional district, we had a number of drop boxes. There was a lot of confusion, and anytime you do something for the first time, that's understandable about how you can actually get a ballot to the ballot box. Now, there is language that says that you cannot just bundle together or mass drop ballots, but this bill would seek to put a little bit finer point on that. What the bill does is that it establishes that the person that drops a ballot has to be a family member, 18 years of age, or a household member, and that person cannot be a campaign volunteer, for example. And it also specifies that you can't drop more than 3 ballots. Why this bill is important, as you've heard on testimony in a number of bills already, some of the ballot drop locations had video surveillance, some didn't. Some had a guard there or a person watching over them, some did not. So because of those different requirements, we don't want anyone to corrupt this process. I will also add, as been said before, to our knowledge, no voter fraud occurred. This bill just seeks to make it so that it doesn't occur. So with that, I'll go ahead and close and take any questions. Thank you, Madam Chair.
Thank you. Delegate Hornberger, my mother and almost half the people who live in her establishment have home health care aides.
Mhm.
You seem to be precluding people like that. How could you?
Yes.
I assume that does not go against the intent of your bill.
Yeah, that is an excellent observation. And in reviewing the bill, we did see that there is areas to sort of remedy this. Also, if there was an elderly person that was living by themselves, for example, they would not be covered. We are open to amendments on this bill. I want to reiterate that this is not our bill. We were asked to cross-file it, and we think that there are some good parts of it that could go a long way just to add peace of mind for voters. So that is an excellent point, Madam Chair, and definitely open to suggestions and forms of amendments. Thank you.
Thank you. Delegate Wilkins?
Thank you, Chair Kaiser. Delegate, during I think it was the general election, I had a constituent called me who had a disability. She lived with her mother who also had a disability, and they missed the deadline for the mail-in voting. And they to request the ballot in order to do the mail-in voting, and they did not have the ability to sort of go up to the Board of Elections, and they didn't really have other family or friends or anyone like that could help them. So it was a very challenging situation. And so for for families like this, and I know that there are a lot across our state who are unable to, physically go and vote, and who might not have a family member. In terms of your bill, how does your bill help ensure that for people with disabilities and others who might be in similar circumstances, that they are able to get a ballot?
Yeah, so that's a great question. In terms of the bill language, it speaks to an authorized individual. So that authorized individual could be a family member, it could be a designee, it could be someone from the State Board of Elections or a volunteer advocacy group, as long as they were not affiliated with a campaign entity. In the anecdotal situation that you use there, where you're kind of up against the clock, I think if they worked with their county board, that there might be an option to have that filled out and mailed back. And I know that there was a postmark requirement as well. So I think that there's different avenues when someone is up against the clock like that. And if those persons that did live in that household were able to find someone and authorize that person, that they would definitely be able to continue to do so if this amended bill passed.
Thank you, Delegate.
Mm-hmm.
Next question, we have several more. Delegate Patterson?
Thank you, Madam Chair. Thank you, Delegate Hornberger, for bringing this bill to us. I'm concerned about operationally, how do you see this working? Is this only in person, or does this apply when you have the ballot box? The reason I ask is because in my community, there have been several rural people who didn't have transportation, who were unable to get their ballots in. And so there were community persons who helped in this delivery. So how do you see this operationally working?
Yeah, that's a great question. So in that instance, there's a couple options. Of course, they could mail it. That does take time. And some folks had apprehension about the mail service just because letters get delayed. And ultimately, you're handing that off to an individual that you don't have a relationship with. It's going through a number of processes before it gets back to the Board of Elections. So the authorized individual, as I spoke to in the last question, could transport those ballots. What this bill really seeks to do is to prevent someone from doing a mass collection of ballots, filling out those ballots, and then potentially dropping them in the box 20, 30, 40 at a time. Currently, there is no strict language that prohibits it. There is language that makes reference to it, and language that says that you cannot do ballot harvesting. However, there aren't definitions, and there's no strict language preventing someone from either going and taking ballots out of mailboxes, because we know when they go out, or fraudulently filling out ballots without someone's knowledge and then turning them in. We did hear earlier in some bill testimony that there were folks that inadvertently, through no fault of their own, voted twice. It was not intentional. In many instances, we don't know exactly what happened, but it was just a slight oversight. And that, frankly, is something that could occur if someone was to either intercept mail or request ballot on behalf of someone without their knowledge. So that is one of the things that this bill attempts to try to assuage.
Assuage, I like it.
Mm-hmm.
Thanks, Delegate Hornberger. Next question that we have is from Delegate Feldmark.
Thank you, Madam Chair. So I just want to kind of understand how this would apply to a situation that we had in my district with a continuing care retirement community. Where, and of course, this was influenced also by the pandemic, but so I believe it was during the primary that staff were, they didn't want residents to come down to the mailroom because that would, they'd be congregating there and there'd be additional interaction. So staff were collecting ballots from individual residents' units. Mm-hmm. How would this bill impact that type of scenario?
So in that instance, it would really come down to those individuals who voted, authorizing that individual. And are you referring to Leisure World?
No,
or
no.
a similar facility like that?
Similar facility, but I guess my question is, does the limit of 3 ballots apply even if someone is authorized by more than 3 voters?
Well, I think in that instance, either, because you still have the option of bringing in someone else, be it a family member or being it someone that's a shared household or shared community. So in terms of the way that the bill is written, yes, that 3 cap would still apply, if that answers your question. And again, we know that that person that participated in that process was of genuine intent and wanted to help make sure that those votes got delivered. But just think about it from the perspective of an innocent bystander who was also dropping off their ballot at the ballot box, and they see someone put 10, 15, 20 ballots inside to a ballot box. That we don't know why it happened, but instances like that can undermine the process. So I think that's one of the things that this bill looks to cut down on.
Thank you, Delegate. Next question, Delegate Ebersol.
Thank you, Madam Chair. I see that you have the family member requirement, but in the next part it says you may not be a campaign volunteer. So if I volunteered on a campaign, I can't deliver my mom's ballot?
Again, Delegate Ebersol, that is a fantastic question. You will also notice that the candidate is not listed on there as being able to be a ballot harvester. So there is definitely improvement for language. But again, I would draw you back to the intent of the bill, which is to prevent ballot harvesting or the perceived of ballot harvesting. But yes, you are correct.
And you somewhat scientifically picked the number 3. There was some study that said that more than 3 put people off and fewer than 3 didn't, if they saw them being dropped off by someone.
Well, I think that a line has to be drawn somewhere in the sand. And, 3 is just as good as a number as any other. But we're definitely open to suggestions.
I like 10. It's one of my favorite numbers. Thank you.
Yeah, I'd hate to see your amendment decimate this bill, but sure.
No amendment, just a favorite number.
Sure.
All right, thank you. Any other questions for Delegate Hornberger? Seeing none, we do have informational testimony provided by Catherine Berry from Mayo. Catherine, are you here? I don't see her at the moment. I'm looking again. just informational. Hopefully there's written testimony that people can take a look at. All right, Delegate Hornberger, your next bill, 691.
Thank you, Madam Chair. For the record again, Delegate Hornberger, HB 691, campaign contributions, disclosure of owned or controlling individuals of a business entity. Now, what this bill seeks to do, currently, as you're probably aware, there are caps on how much businesses can make contributions towards political campaigns of $6,000. There is also a cap on individuals of $6,000 and spouses. So if you were particularly inclined to help out a candidate, you may stroke that candidate a check for $6,000, and then you say, oh, well, I have this business here too that I can donate from. I'm going to give you $6,000 as well from that. However, there are entities out there, such as businesses, that might not want you to know that they're making donations to certain candidates, or that they're making large aggregate donations to those said candidates. And the way to get around what this body enacted a few years ago, which is called the LLC loophole, was closed, is that if you own multiple LLCs, as long as you are in the ownership of those businesses, you are still subject to that cap. So what we're seeing now is kind of a workaround with some of these bad actors, is they might control 10 companies, 6 companies, 8 companies, and they will write a check from each one of those companies in a small cap amount, $250, $500, so as to not alert anyone that they're making these large aggregate contributions. Now, you as the constituent, or even someone like Jared Demarinis, who works for SBE, has a very difficult task of auditing these sort of donations, because at face value, they can't tell if you own all of these companies and then if you've exceeded the amount, or if you've made this $6,000 contribution. So what this bill seeks to do is to basically create another column for those of you that have helped with treasurer reports, where you, the candidate, would disclose a unified accepted number by the state of Maryland for any donations that are received. We also have an amendment with this bill, because we have been working with the advocates, SBE and SSTAT, that would make passage of this bill dependent on Mike McKay's bill, Delegate Mike McKay's bill that we heard earlier, HB 441, that is going to create this, what I'll call globalist harmonious number for business entities. So at the end of the day, this is a transparency bill, and will go a long way to show what candidates are getting what donations. I will also add that from a taxonomy standpoint, let's say that I have a company called Blue Collar Engineering, for example, and I want to make donations to you over a period of time. I can write you a check for $1,000, and I can say that it's from BCE Inc. I can write you another check that says Blue Collar Inc. And I can write you a third check that says BC Engineering. And as a candidate, you can inadvertently or purposely put that in as 3 different campaign contributions from different entities. And a viewer, a constituent, an auditor would be none the wiser. So even if you have one company and you want to skirt this transparency, you are able to do so, because there's no standardized naming practice for when putting reports together. So by adding this extra column and having to put that SDOT number, which will be readily available, it goes a long way in transparency of where these donor dollars are coming from. And with that, I'll take any questions, Madam Chair. Thank you.
Thank you, Delegate. We will take a question, and I think you have somebody testifying on this bill, and I missed on the last bill, Ms. Demnowitz, who we will come back to after we're done with 691. Questions for you on this bill, Delegate Hornberger. Delegate Buckle?
Delegate Hornberger, I'm a little confused as to what it is exactly we're trying to do, because the presentation you gave was very detailed, but everything that you just said, I think, unless I missed something, would not be illegal. So we have a law that says that you have these $6,000 per entity caps.
Mm-hmm.
And I think, and I may be getting this wrong, but I think that the law says that as long as the LLC or the entity is not owned 80% by the same people. So if you have an LLC that's not 80% the same ownership structure, then that's a separate LLC and they can donate separate amounts of money. So what you've talked to me a lot about today, or talked with us a lot about today, is you just want people to record on their report that yes, LLC number one is related to or the same as LLC number two, but you're not suggesting in any way that you're changing the aggregate cap limits that they can donate, right? I mean, what they were doing in the example you gave of the 3 different LLCs all donating $500 to the same candidate, that's completely legal because it's all within the cap.
Yes, that's correct. Is that a question?
Yeah, that's a question. So what's
Okay.
the point of the bill so that you can look at your opponent's finance report and go, oh my gosh, my next door neighbor, I thought he liked me, but instead his 3 LLCs have all ganged up and sent $2,000 to my opponent.
Sure. Great question. So I have to answer that question by saying, what is the purpose of generating a campaign finance report? All right. The purpose of generating a report is so that we, the constituents, can look at that report and see where the money comes from. Now, that example that I gave you about my blue collar engineering donation, currently, if I look that up and it's under a different name, be it accident or intentionally, I, as the viewer, have no idea who owns that company. It's just a name. It may have been created solely for the purpose of the election and then shuttered later. It may be registered in Delaware or Nevada to hide the folks that own that company. By adding this additional column, you will be able to go to SStat and see how that company is organized, who owns it, shareholders, et cetera, background on that company. That's step number 1. Step number 2 is the ability to audit. Okay.
Hold on a second, because the state doesn't record who LLC members are. When you form an LLC in the state of Maryland, there's no legal requirement. SStat doesn't have the membership or the units of who owns an LLC. I form LLCs every week, and we don't give them that. We just give them a principal partner or a principal member and a someone for service of process.
You can't get there from just a name. You can get there if they're entity registered with the state. So there's the ability to exercise that diligence and find out. And there's also the ability to see if it's under multiple different names is number 1. Number 2, from an auditing standpoint, SBE doesn't have infinite resources. There's been numerous cases, especially in past gubernatorial cycles, where folks have exceeded that cap. And it's been very difficult to track down. And many times it's not found out until long after the election is over. So for a little bit of prevention on the front end, it makes it easier for not only the constituent, but for Maryland Department of Elections to conduct their audits, and fits in well with the bill that Delegate McKay had proposed earlier. So I hope that answers your questions.
Fair enough for today. Thank you.
Thank you.
Thank you, Delegate Buckle. Delegate Palakovich-Carr?
Thank you, Madam Chair. Thank you, Delegate Hornberger, for this legislation. I very much appreciate the spirit of transparency. Something I hope the General Assembly continues to move towards. I guess I have a logistical question, and maybe your amendment addresses this, but from the campaign's perspective, how would they know the information about who the controlling company is? Because if you just get like a check that says it's from ABC LLC, how do you know who owns them? Would you have to return the contribution? Like, what do the logistics look like for a campaign?
Yeah, so we've seen a great deal of changes here recently on our campaign finance reports, if you've been following along with your treasurer. One is like disclosure of the employer of a contributive individual, right? And this is no different from that. If you do receive a check from a company, I would think that everyone would want to know, hey, where is this money coming from? Is this a valid entity? And it would be no more difficult than just checking with who that check came from or that donation came from to be able to receive that number. And historically, Maryland has different ways of organizing businesses, be it the comptroller's office, we heard about that, or SStat. So by having this one universal number, it's going to be something that's going to be easy to get and put in that field. So I hope that answers your question.
It does. Thank you.
Yep.
Delegate Feldmark?
So thank you, Madam Chair. This is related. So just as a follow-up to clarify, the candidate or the campaign would not be responsible for due diligence to determine the owner. They would be able to rely on the information submitted with
That
the
is correct.
contribution. Is that?
Yeah,
Okay.
it would be no different than verifying an address, for example. And what I will say is that as things tend to get more digital and move more online, there are a number of fundraising platforms that require this disclosure on the front end as we start to move farther away from checks and in-person fundraising. So this would be able to be captured there as well.
All right, thank you. Seeing no more questions for Delegate Hornberger, on 691 we have Christy Demnowitz and Ashley Sparks. Christy, if you can just officially talk about 691, and then we'll come back to you on that first bill 690.
Problem, and thank you. Thank you, Madam Chair Kaiser and members of the committee, and thank you to Delegate Hornberger for introducing this bill. So just again, my name is Christy Demnowitz, and I'm the chair of Represent Maryland, and we are a pro-democracy PAC in the state of Maryland. We work on a number of pro-democracy legislative solutions. One of them, kind of umbrella, is transparency. But we also have a program that's called Represent Maryland's Small Money Commission, where we, for the past 2 election cycles, have researched candidates' campaign finance donations to see if the donations fall under some criteria that we've established for our own organization, which we consider to be small money candidates. And we have seen a lot of what Delegate Hornberger has described. There's many candidates who have a number of donations from what appears to be the same entity. And we know this because they're often the same address, and the only way that you can tell is because they're the same address. Yep. And we'll go into Google Maps or Google and search the address, and it'll come up to have several entities. So it looks like they are either hosting a lot of shell companies, or it's sometimes a person's house and they have multiple LLCs that are stacked. So we do see what he's talking about when we do this work. And basically, there are a lot of constituents. This isn't something that's for candidates. This is for constituents, so that they can see who's giving money and how it's, how that system is connected and how different LLCs are connected to one another, because it is a very complex web of money that's being used to fund elections. So we definitely support this this piece of legislation. We think it's a really important thing to do. We think it's an easy thing to do. As a PAC, we have fundraising, and we have an online system where all we have to do is add in another line that says, are you the principal owner of a business? And they can put that in there. And that it is on the donor to supply that information, but anything that we can do to increase transparency in the money that's going into politics is important. So that's why we support this bill, and hope you will find it favorable. Thank you.
Thank you very much, Ms. Demnowitz. We next have Ashley Sparks.
Thank you, Madam Chair and members of the committee. My name is Ashley Sparks, and I'm a board member for Get Money Out Maryland. So I'm filling in for Charlie Cooper today, for those who are used to him. On behalf of Get Money Out Maryland, I would like to support HB 0691. We agree with what has been stated. This is about us constituents getting to know where the money is coming from and for our purposes, and it really simplifies for us. We had one kind of general amendment when we first read it, which went along with the lines of what a lot of people seem to be curious about. Is we feared at first this seemed to put a lot of ownership on the treasurer to fill this out. And so instead we had offered an amendment where it would be on the corporation or the business to disclose that information, so a treasurer wouldn't have to go searching. It sounds, if I'm understanding correctly, that is a little bit helped out by the other amendment that's being offered, but we don't want to add undue burden to a overworked treasurer as is. But we do support the idea behind this bill, and we hope you find it favorable.
Thank you. Any questions for Ms. Demnowitz or Ms. Sparks? All right, thank you both very much. Ms. Demnowitz, again, I apologize for missing you. I was on the wrong page of testimony when we were on 690. I want to go back to you for your testimony on House Bill 690.
Sure, thanks. And no problem for that. Again, Christy Demnowitz, Chair of Represent Maryland. And for this bill, we submitted favorable with amendment testimony. It was written by one of our supporters, so it's actually written by a woman named Sigourney Frazier. But I just want to kind of recap what she had written because she's not able to be here today. She works in the healthcare field, mental health care specifically, and going in line with what I believe everybody else kind of agreed with. What's written in the bill is not inclusive enough people to be able to deliver ballots. So we would like to see the bill to be expanded to include not health providers, but mental health providers, social workers, things like that. Not exactly sure what that list would be, but there's definitely people who assist voters on a daily basis who should be able to also submit their ballot if needed. We also believe that the number 3 is too low because if you are a professional home health nurse and you visit multiple patients that can't get out otherwise, it's going to be more than 3 ballots. But we do want to reiterate what Delegate Hornberger said, which is that this responsibility should not be a partisan responsibility. It should be the responsibility of other members of society. Whether it's a family member, whether it's an aide, whether it's somebody else that has that relationship with a voter, we think it should be inclusive of all those different types of people. And the reason that this has become a partisan responsibility is because nobody else was taking this on. So candidates said, oh, this is something we can do. And then they did it. So what we'd really like to see is if the State Board of Elections, although they're very overburdened with other things, had maybe a volunteer squad of people who this was their sole responsibility. It's 100% nonpartisan, but they're able to help get voters' ballots to the ballot box. And if that isn't possible, we think that mail-in voting, universal mail-in voting is another way to solve this problem of people not being able to cast their vote, even though they should be. So just to recap, this shouldn't be a partisan responsibility, and there's a lot of ways we can fix it, but it needs to be inclusive of as many different solutions as possible. Thank you.
Thank you, Ms. Demnowitz. Again, everyone back on 690. Were there any questions there? All right, we're done again on House Bill 690 and now 691. Delegate Hornberger, your next bill, 694.
Thank you, Madam Chair. 50% of the way there. Glass is half full. I'd like to present to you House Bill 694. This was requested as a cross-file from Senator Gallion of SB 340. And the title of this bill is Election Law Offenses Relating to Voting. All this bill does, pretty straightforward, is it is established that someone is ineligible to vote if they knowingly voted more than once and were convicted in an election that was less than 4 years ago. Very simple and straightforward. There have been folks that have inadvertently voted twice. Those have been worked out. The bar is very high for being convicted of duplicate voting. However, there is no, from what I can gather, law that states that you can't vote in future elections if you commit that crime and are convicted. So with that, we'll take any questions.
Delegate Hornberger, I guess I would direct my questions to Mr. DeMarinis, who's not signed up to testify. In terms of if you have any, well, maybe the first question is to Delegate Hornberger. How often are people ever convicted of that kind of voter fraud? And then secondly, just to confirm with Mr. DeMarinis that there is not already a procedure in place to keep someone like that from voting in the future. So,
Madam Chair, I'll answer that first question you posed. I don't have any numbers for convictions of voter fraud. However, I will point your attention to a recent congressional campaign in District 1 where someone that was running for office was found to have voted twice in an election in different states.
Well, while that was true that she voted both in Maryland and in Florida, was she convicted?
I do not believe so.
Okay, so this wouldn't then apply to her anyway?
Correct, but you would ask if there was evidence of people voting twice.
Sure. Yep. No, I meant if they were convicted of it, actually. And then, Mr. DeMarinis, what do we do if someone's convicted of this?
I would have to check with the state prosecutor's office to see if there would be penalties associated with future voting, or if it would be a part of their probation or anything to that matter. But that would be with the enforcement, because we would just be referring the matters of double voters to the state prosecutor's office, and they would be the one that handles the actual enforcement of that issue. So I'll double check with them and get back to you, Chair.
Thank you. Any other questions for Delegate Hornberger? All right, thank you, Delegate Hornberger. Seeing no other questions and no one else signed up to testify. Delegate House Bill 695.
Thank you, Madam Chair. Final bill for the day, I promise. And our colleague, Delegate Jay Walker, isn't here, so I'm hoping that one of the other delegates can chime in with a summer breeze reference. But this bill is a study, and what this bill intends to do is to create what will be the most progressive and most transparent campaign finance transaction ledger in the country. Now, how do we accomplish that? You are all very familiar with online banking, I'm sure. The ability to go into your checking account, savings account, and watch almost in real time those transactions take place. I just wrote a check and it was deposited. I just used my debit card at the gas station, for example. That technology has been in existence for almost a decade. Now, parlay that over to your campaign finance report. You make transactions, you buy mailers, you buy signs, you pay consultants, etc. The voter doesn't know about that until you file your report. And many of those transactions, be it they put in late, be the reporting deadline is later, in many instances, they're not found out until about after the election is already over. So what this study would seek to do is to work with certain stakeholders. The Maryland Bankers Association is listed as one of those potential stakeholders. And it would come up with a fully visible, anywhere there's net access, internet access, ability to look at transactions as they happen live. And in working with SBE and some of the advocates, this technology is already there. Our campaign finance reporting system can already do this. It's just a matter of what it looks like and what that final product represents. Now, the item that I wanted to add to this is that in being able to see all these transactions and having that accurate ledger, we can see if someone has put in a large donation rate at the end or where that campaign contribution has come from. But here's the holy grail and where this bill seeks to take this. This bill seeks to allow for grassroots candidates to be able to run for office. And the reason I say that is because identifying a treasurer and then getting that non-paid treasurer to compile all these reports, to meet all the standards, to meet all the strict deadlines is very onerous. Many candidates that have large purses, hundreds of thousands of dollars in their campaign, they can pay a treasurer to do these reports. However, grassroots candidates often rely on their spouse. They rely on someone who has a full-time job or someone in the community that maybe is an advocate who isn't an expert in this field. They're not used to doing P&L statements or complex Excel migration, etc. So this bill could potentially diminish, once enacted, the ability to have to constantly be submitting these reports. And keep in mind, many of these reports have to be submitted in the heat of the campaign. When we have so many other things going on, money coming in, money going out, paying vendors, going to events, doing mailers, etc. So this, and I have constituents who live in my district who, quite frankly, have run for office, had a treasurer who wasn't super competent on the platform. They've incurred fines, they've incurred fees, they've erroneously closed out their bank account, can't get access to records. Well, guess what? Those folks that have made those mistakes, until they remedy them, they are barred from running for office again because they're not in good compliance or good standing with their treasurer account. So this bill, again, is just a study. It doesn't obligate anybody to do anything or interact or enact anything. However, it's something that I think we should move towards, and it'll go a big way for transparency and the ability for genuine grassroots candidates to get involved. And with that, I'd like to take any questions, Madam Chair.
Thank you, Delegate Hornberger. Any questions for Delegate Hornberger? Any questions? All right, seeing none, we just have Christy Demnowitz signed up to testify.
Yes, thank you. Hello again. Christy Demnowitz, Chair of Represent Maryland. And we are a PAC, so we have a treasurer who's a volunteer, and the campaign finance reporting system, now it's easy to use because we've been using it for 4 years, but at the beginning we made a lot of mistakes and didn't understand the whole process. And so we like this bill because anything that we can do to help figure out how to make both the process easier and the information that is shared from candidates more transparent and more public and more instant is going to be good for our democratic process and good for constituents and good for, politics in general. Some of the stuff that Delegate Hornberger said about what this could lead to, we don't necessarily agree with, but again, this is just a study. And so we think it's important to look at what the options are when it comes to real-time reporting, connecting campaign committees with bank accounts and things like that. So we definitely think this bill is something that should be considered, and it would show that the state, that the legislature is serious about transparency when it comes to campaign finance. And a lot of the stuff that's been happening in politics around the country and here in Maryland comes down to lack of faith in government. So this is something that could be done to show that that lawmakers are trying to restore faith in government and faith in lawmakers and faith in the political process. So we definitely support this bill. There's nothing to lose. It's just a study. And we would like to see what can come out of that study to see if it makes sense to implement it into our systems. Thank you.
Thank you, Ms. Demnowitz. Any questions? All right, thank you. Seeing none, we are done with the hearing on House Bill 695. Supposed to move next to Senate Bill 496, but I was told they are still logging on. I don't know if either Delegate Chisholm or Delegate Crosby. Delegate Crosby, why don't you do House Bill 656, the shorter of the two, first?
Yes, thank you, Madam Chair. It's so good to see you. And good afternoon, Madam Chair, Mr. Vice Chair, distinguished members of the committee. I am Delegate Brian Crosby, here to present House Bill 656, entitled Election Law, Early Voting Centers, Accessibility by Public Transportation. Members, you may recall that last year I submitted the bill with similar intent, but this year's version, after working in the interim with former delegate, now Councilman Mosby, Mako, and the State Board of Elections, we've made a resolution that we think is workable at the local level. Each of you should be able to access the updated language of the amendment that I have offered to the committee. But in short, the purpose of this bill is to ensure that all Marylanders have the capacity to participate in early voting by requiring any bus route that typically passes within 1/2 mile of any early voting center to adjust its route during the early voting times so that passengers can embark and disembark as close to the entrance as possible. My county only contains one early voting location, and despite being one of the largest in the state by area, and is not easily accessible for transit-dependent voters from our most populated area, Lexington Park, because it is not near a designated public transit stop or station. Instead, we have a flag system, so residents must flag down the bus while waiting alongside a major highway, and this not only presents a serious safety concern and an impediment to many of my constituents attempting to perform their civic duty, but then once they get off that bus, they're about 1,200 feet away and they have to go up a hill. And if there's snow or inclement weather, it makes it even more difficult. Providing access to in-person early voting should be a priority for the state and local governments during any election season. And in Maryland, many of you know we have 660,000 disabled residents, 560,000 residents living below the poverty line, and 1.2 million elderly residents, many whom rely on public transportation as their primary means of transportation. We must remove barriers that our constituents face in fulfilling their most basic and important constitutional right. And I think increasing accessibility to early voting locations throughout public transit route adjustments will help ensure that hundreds of thousands of eligible voters encounter one less barrier to casting their ballot. And for these reasons, I urge the committee to find a favorable report on House Bill 656.
Thank you so much, Delegate Crosby. Delegate Epperson?
Madam Chair. So I'm a little confused, and I want to make sure I have it right. I read the bill to say that the centers would have to be located near the route, or the route would have to be bent. But if there's no route relatively close to start with, does that preclude having a voting center there?
No, it would not preclude having a voting center there.
I'm
Go
sorry.
ahead. No, go ahead.
you.
Yeah, it doesn't preclude it, nor does it say that, hey, if you have public transit in that county, that they have to significantly adjust that route to make sure it goes in front of the voting location or voting center that doesn't have public transportation within a half mile of it.
So it's just if there is a route within a certain distance, then they have to bend it a bit to get it close enough, reasonably close. Is that the idea?
Correct. Yes.
Okay, thank you.
Thank you. Any other questions for Delegate Crosby? Delegate, I just want to quickly ask, what when you worked on this during the interim with Delegate Mosby, what did you come to? What did you discover in the process?
So I think we really just changed the practicability of it, Madam Chair. Originally, it said we wanted to make sure that early voting centers had public transit within a half mile, but many voting centers, as Delegate Ebersol just mentioned, don't even have access to public transit anywhere to it. So it doesn't make it really practical to mandate that we start putting in all these major bus routes and making counties jump through hoops. So really, it was just trying to find a practical solution. And I think, Jared could probably comment on this, but I'm pretty sure that we had, 2 or 3 meetings at least. And then we had a meeting earlier last week, I think, with Mako to finally nail down a practical solution.
All right, thank you. Any other questions? All right, we do have our representatives here from the governor's office. I do know you have another bill, Delegate Crosby, with more than 20 people testifying. So we have to move to the governor's office first while we told them we'd take them at 2:15. Now they're here. We have Kiefer Mitchell and Ali Keene, I believe, from the governor's office, Senate Bill 496.
Good afternoon, Chair. Good afternoon, members of the committee. Kiefer Mitchell, Chief Legislative Officer for the Governor's Office, joined here by Ali Keene in our office. We are here in support of the Governor's bill. We appreciate the work that the Senate and the House has been doing in terms of moving the Governor's #1 priority, the Relief Act of 2021. Through the legislature, and we really appreciate the work that this committee has been doing and other members of the legislature with our office. So at this time, I'm going to turn it over to Ali Keene just to talk about what the governor's thoughts and statement.
Yes, thank you, Madam Chair. I just wanted to read what the governor put out in response to Senate Bill 496 passing last week. I want to thank the Senate for their swift and unanimous passage of the Relief Act, which will provide immediate tax relief and economic stimulus for struggling Maryland families, small businesses, and those who have lost their jobs due to the pandemic. This is what effective and bipartisan leadership looks like. And I want to extend that same notion to the House for your quick movement on the Relief Act. And we look forward to putting out another bipartisan alert very shortly here. So thank you.
Thank you, Ms. Keene. Thank you both, and very concise testimony. And Mr. Mitchell, we sure hope you're feeling better from your broken rib. And
it's good. It's good to be back, and I'm looking forward to testifying on any opioid task force or narcotics task force that you all may have in terms of my firsthand experience.
Just take that out of the video, please.
we'll cut that. We'll try to cut that out.
Thank you.
Here you go. Thank you for the well wishes from all the committee members texting me and their offers of support. Thank you.
Delegate Lutke with a question.
Not a question, Madam Chair, but I just wanted to let the committee know not to preclude any questions, but this is the same, similar bill to what we heard last week that was introduced by the governor's office. As you know, the Senate amendments included the addition of $520 million of spending on various priorities related to the pandemic. House and Senate leadership and the governor's office have been having conversations about the bill. And we think we are in a place where we will be able to present the committee tomorrow with legislation that has been informed by conversations with a number of members of the subcommittee as well as ECM. And that, at the end of the day, I think we'll be able to come up with something where everybody involved can vote yes, help out a lot of people, help out a lot of businesses, and sing Kumbaya.
All right. Thank you, Delegate Lukey. Are there any questions for Ms. Keene or Mr. Mitchell? Of course, this is sponsor only, so no one else is testifying. Seeing no other questions, we will move to House Bill 662. Welcome, Delegate Chisholm.
Thank you.
Thank you.
I see he's, I know that I admitted him and I see he's still connecting in. Delegate Chisholm? There you go. Still muted.
Thank you, Madam Chair. Thank you, Mr. Vice Chair. For the record, I'm Delegate Brian Chisholm here to present HB 662. It's just a local tax credit bill enabling legislation to let the county executive and the county council of Anne Arundel County the ability to offer property tax credits to commercial properties. Businesses have been impacted negatively in a state of emergency both now and in the future. The bill does not suggest, does not mandate, does not instruct the Anne Arundel County Council or the Anne Arundel County Executive to do anything that they do not wish to do. It's just simply what we've been asking for the last 10 months. We're just trying to give them more tools to and more flexibility to offer help to businesses wherever they can, however they can, if they see fit for any business that's been impacted. One of the quickest things we can do is to help them with their property tax, with a property tax credit to put some more money back in their pocket rather than waiting around for a grant or federal money to come through at some point. So it's just hopefully will be used in a positive way in the future or soon for any businesses that need the help.
Thank you, Delegate Chisholm. We do have a few questions for you, Delegate Buckle.
Thank you, Madam Chair. And, I really appreciate this bill, Delegate Chisholm. And when I looked at it this morning, I thought to myself, I appreciate how we do things here. And you put this in specifically for your county. You've testified it's enabling only. And it's my understanding, correct me if I'm wrong, we would have to do this for any county government to be able to offer these types of tax credits. So while it's a county decision to make, a local decision to make whether they do it or not, they have to get authorization from the General Assembly and the state government first, simply to enable them. Is that fair?
That is fair and that is correct.
Okay. So would you have any problem, if we expanded this concept? I think it's a really good concept to allow maybe other counties in the state to do this if they so choose. We're just enabling maybe my county, maybe other counties to offer these credits to help businesses in COVID-19. And if they choose not to, they don't think they can afford it, that's up to them. You wouldn't have any problem with expanding that concept out, would you?
No, that would be a very welcome concept and would be great legislation to help out throughout the entire state, depending on what the state of emergency is.
Thank you.
Delegate Lukey with question.
Thank you, Madam Chair. Delegate Chisholm, thank you for the bill. So this bill only applies to real property tax, right?
That's correct.
Okay. So Delegate Buckle, have I got a bill for you? Because it looks like Delegate Kerr and Senator Alfred have introduced a statewide bill that would apply to both real and personal property tax and authorize any county in the state. Delegate Chisholm, I assume that if that were to pass, you'd be comfortable since it gives that broad authorization?
That would make me extremely comfortable, and I think it would be outstanding legislation.
Great.
Thank you, Madam Chair.
Thank you.
All right. Thank you. It's a local bill. This is sponsor only. Are there any other questions? All right. If not, I'll be turning it over to the Vice Chair for House Bill 655.
Thank you, Madam Chair.
All right, House Bill 655, Delegate Crosby.
Thank you. Good afternoon. Thank you, Madam Chair, Mr. Vice Chair, and honorable members of the committee. For the record, my name is Delegate Brian Crosby, and it's an honor to present House Bill 655 entitled Local Government County Commissioner Elections District Voting. This bill is about fairness, equality, and diversity. It improves democracy at the local level by ending a Jim Crow era policy of electing representatives in a manner that disenfranchises non-white voters. For decades, several counties in Maryland have operated under an at-large voting system for county commissioner elections. Although county commissioners are required to reside in the district they represent, they are voted on by citizens outside of their district. I believe that the citizens of each county commissioner district have the right to select who represents their interests without influence from voters outside their district. In my home county, St. Mary's, the Lexington Park and Great Mills area are home to the largest population of non-white voters. This systemic disenfranchisement totally dilutes their electoral vote by adding votes from the rest of the county, and they are left without an advocate for their own community's needs. Basically, if you are a low-income person of color in Lexington Park and Great Mills, you have generational knowledge that you will not have a voice at the county level. In fact, the system has taught you that your vote doesn't matter. And I've heard this time and time again over the last 3 years since I've been campaigning and then elected. Is that really what we want to do to the citizens in our state? The dilution of voting power is simply anti-democratic. And in fact, according to Section 2 of the United States Voting Rights Act of 1965, state and local governments are prohibited from imposing any law that results in discrimination against racial or linguistic minorities. Because this at-large voting essentially silences the vote of the largest community of Black and brown people in our county, we are allowing a violation of the Voting Rights Act right here in Maryland. We've already been through this in the 80s in Dorchester County, and now it's again happening under our watch. Our democracy is built on the idea of one person, one vote, and the current system violates this principle. Black History Month is a great month to pass a law that ends this disenfranchisement of minority voters. Actually, it's a great month to do anything that puts us on a trajectory towards a more fair and equitable future. We, the General Assembly, have the opportunity to make this change before the Justice Department gets involved, and passing this law creates a more representative form of government and is the morally right thing to do. I urge the committee for a favorable report on House Bill 655. And Mr. Chair, I don't know, I do have a small panel, but I don't know how you're doing it. So if you wanted to call them as order they signed up, totally get that too.
Thank you. We're going to take questions for you first, Delegate.
Okay.
And then if you want to, if you can't answer the question and want to divert it back to your panel, you can do that. And we can, as we bring them up, they can answer those questions too. So let's take a first few questions for you first. Delegate Patterson first.
Thank you, Mr. Vice Chair, and thank you very much, Delegate Crosby, for this bill. I just need some clarification because I've gotten quite a number of inquiries from my county, Charles, which has, I understand the situation in St. Mary's, but that is not the situation, fortunately, in our county. The question is, does the bill only impact or affect those counties that are commission-driven, i.e. Calvert, Carroll, Garrett, St. Mary's, Somerset, and Washington, versus counties such as those that are code rule, such that include Allegheny, Carroll, Charles, Kent, Queen Anne's, and Worcester? In other words, does the bill only impact the commission districts versus that are code?
Delegate Patterson, and I appreciate our previous conversations on this bill. The short answer is no. Code home rule or commission forms of government have nothing to do with the bill and wouldn't impact it. It only impacts 5 counties which have commissioner districts and then they vote on them at large. So those 5 counties are my county of St. Mary's County, your county of Charles County, Calvert County, Queen Anne, and Garrett County. They're the only 5 counties that this impacts because they have districts set up and then you vote on those districts at large.
Thank you, Delegate Crosby, for the clarity.
Thank you. Delegate Buckle.
Thank you, Mr. Vice Chair. Delegate Crosby, you just walked through some of those counties. And you gave a presentation, you used a lot of very significant language, basically imputing and suggesting the motives of why this happens in your county. But in looking at the file, you know, Calvert County, Queen Anne's County, Garrett County, none of these counties want your bill that do what you're purporting. They elect commissioners, they have districts, but they count the votes countywide, essentially. Why can't you just do your bill as a local bill for St. Mary's County if the people of St. Mary's County feel that it's so significant? Why does it have to be a statewide bill affecting everyone that doesn't seem to be having these problems?
So I would say a couple things. The first is it's a statewide bill and it is the morally right thing to do. Secondly, for the reasons that I discussed in my testimony, it wasn't that it's just disingenuous in my county. This was disingenuous through Maryland. In the 1980s, Dorchester County had a similar system. And then that was heard in front of a court where the ruling came down and said, yeah, this is a violation of the Voting Rights Act. And then they put it on a ballot to see if it was constitutional or not. And subsequently, Dorchester County was split into 5 voting districts where the voting system is exactly what we researched and is what we are proposing today. So it's not necessarily a slight just on those counties. I also think that there's, let's just be real about this. Why would the majority, the political majority, give up having 5 votes for 1? And I don't think that they're going to do that without us as the state interjecting into that.
When you say that all these counties that do this way must be some Voting Rights Act or constitutional discriminatory action, do you know what the African American population of Garrett County is? Do you think that in Garrett County that has 3 districts that somehow Garrett County is committing a Voting Rights Act violation despite the fact that I think their African American population is less than 2% at the time of the 2010 census? So I think you're just painting things with such a brush because of the situation you perceive in Lexington Park. Can't we just do this as a St. Mary's bill if people of St. Mary's County want it this way?
So maybe Garrett County doesn't necessarily have the same lawsuit that we would, may have in Lexington Park. However, it doesn't mean that the overall system, when it was set up in what I can tell is in 1851, wasn't designed to disenfranchise minority voters. So just because it doesn't necessarily happen as a percentage there in Garrett County, the system was set up that way. And that if the African-American population grew in Garrett County, then I'm sure that they would want their voice heard as well.
I'll just have one final question. I'll just have to disagree with you about that, but I'll give you one question. Has the St. Mary's County delegation or the St. Mary's County commissioners endorsed or requested or given approval to this bill, or do they disagree with it?
No, you will hear their opposition testimony later this afternoon.
Okay, thank you.
All right, thank you. Delegate Fillmore, I guess you just down, you no longer have a question.
I think I'm good, thank you.
Okay, and I think I saw, before we go to the chairwoman, Delegate Lasanti, you dropped your hand, right? Okay, Delegate Wilkins, go ahead.
Thank you so much, Mr. Chair, and thank you, Delegate Crosby, for bringing this bill. I think it's such an important conversation, especially at a time like this. Can you talk more about how this bill will help enfranchise voters, especially minority voters?
I can, Delegate Wilkins, and thank you so much for the question. It's actually, the best way I can describe it is if you go to my testimony, we attached a slide that we built out. And that really explains how this would help minority voters. And really, it may be green and yellow we have for the districts, but if you picture a 4-district system where let's just say each district has 6 votes, and in districts 1 and 3, the vote tally is 4 green to 2 yellow, and in districts 2 and 4, the vote tallies are 5 yellow and 1 green. In the end, you end up with a system that has 14 yellow votes, which is 58% of the vote, and 10 green votes, which is 42% of the vote. And so if you have, let's just say District 1 was predominantly African-American, and African-Americans make up 20% of my county, well, if you allow it to go to a countywide vote, then they're going to lose approximately 60-40 in the vote, as opposed to having an African-American candidate who can run in that district and would win that district at a 2-to-1 clip. And so what you end up with on the county commissioner side is somebody who isn't actually, or a board, it's not anybody individual, and I'm not, casting anything against any one of our county commissioners, but you end up with a board that doesn't necessarily look like the community that it represents. And so instead of having 1/5 of the vote being African-American, let's just say it's from the example I gave, from District 1, you end up with 5-0 the other way. And so your voice is essentially silenced as a minority coming from District 1.
Thank you, Delegate. Yep, thank you. Any other questions? Delegate Buckle, you mind lowering your hand for us? So I'm not thrown off here. And let me go to thank you, sir. And let's go to the next couple of speakers here. We're gonna go with a panel of 4 people, and then we're gonna ask any questions that we might have. We have first up Vicky Volk, and then next David Dedrick, or Derek. Sorry, man.
Thank you, Madam Chair, Mr. Vice Chair, members of the House Ways and Means Committee. Lexington Park is one of 2 development districts in rural St. Mary's County. Leonardtown has its own government run by a mayor. Lexington Park is a more urbanized area without a civic agency committed to its oversight. Rampant crime, vacant buildings, and crumbling infrastructure display its neglect. Naval Air Station Patuxent River is St. Mary's largest employer with 22,000 workers, contributing over $7.5 billion to the economy of Maryland. Directly outside its gates is Lexington Park. There is no representation of government that is directly beholden to these urban needs. There is no one to explain that blight allowed to overcome the county's major commercial district impacts every taxpayer. House Bill 655 addresses this deficit. This is not a partisan issue. It is not about the performance of this or any past board of county commissioners. Population and development patterns dilute Lexington Park's voice. Yet the consequences of neglect keep growing for every St. Mary's County taxpayer. It is overdue to address these issues with representation. St. Mary's County Community Development Corporation, which I represent, I'm the CEO, is a nonprofit. It was founded in 1985, mostly to acquire state and federal grants to patch up problems in Lexington Park. That has not been enough. We support direct representation of Lexington Park in county government as a needed step toward restoring this community's safety, health, and property value. We ask for a favorable report. Thank you so much for your time.
No, thank you. Next, we'll have David Dedrick.
Madam Chair, Mr. Vice Chair, and members of the House Ways and Means Committee. I am David Dedrick, a 26-year resident of Lexington Park in St. Mary's County, and I'm speaking in support of HB 655. The method of electing district members to the Board of County Commissioners through at-large countywide voting, currently the practice in just a few of Maryland's counties, is simply wrong. It is not equitable or just, as it discriminates against the electoral power of the very people district membership purports to represent. The current practice robs people within each commissioner district of their vote on matters of concern within the district. It yields instead to the influence of those who potentially have no concern for those matters, whether of policy, infrastructure, or relief so critical to the district. Thus, it nullifies votes, taking away from citizens the very representation that a democracy is designed to ensure, subjecting their votes to gerrymandering without bothering to change district boundaries. It is fundamental to democratic elections that the people within a jurisdiction be empowered to elect their own representatives. To deny them this power is to engage arguably in a form of voter suppression by diluting their vote and denying proper representation. HB 655 will make districts more representative, giving electoral power where it belongs with a precision that a representative system intends. Thus, I ask for a favorable report on this bill.
Thank you. Next, we'll have Elizabeth Yokely. Yokely, you there?
I'm sorry, I was having trouble unmuting.
Okay. Can you also turn your video on as well for us?
Yes, sir, I'm trying to.
Thank you very much.
You're welcome. There we go.
You may begin. Go ahead.
Madam Chair, Vice Chair, and members of the House Ways and Means Committee, my name is Liz Yokely. I'm a resident of Great Mills, Maryland. As a government teacher at Great Mills High School, I teach my sophomores about the Constitution and representative democracy. We are currently learning about how states draw districts to elect members to the House of Representatives and the House of Delegates. What's the point of having a county commissioner represent a district if they aren't elected from the district? I am a resident of the 4th Commissioner District of St. Mary's County. Our district encompasses the population center of the county. Our demographics vary greatly, as you've heard, from the rest of the county. To name just a few examples from our largest town, Lexington Park, in the 2010 census, St. Mary's County was 15% African-American, while Lexington Park was 37% African-American. 7% of our county lived in poverty, while 14% of Lexington Park did. 71% of our county residents live in a home they own, while only 38% of the residents of Lexington Park do. The residents of my district have vastly different interests than the rest of the county, yet the entire county gets to vote for our commissioner, diluting the votes of the people who live here. This is disenfranchisement, plain and simple. Our commissioner in our district does not represent the best interests of the majority of our district. Yet, the majority has no chance of electing someone who does, as long as at-large voting continues. Our commissioner does not advocate for our district, rather works to please the voters throughout the rest of the county. He makes rude, judgmental comments such as, these kids are out there running around with guns. They don't have a conscience. It's a mess out here. From the Enterprise, 9/4/20. He speaks ill of our youth, but doesn't vote in favor of initiatives that could help them. Our community has been working toward a community center for years. Our commissioner should be leading the way, not standing in the way. At a March for Equality held in our county in June of 2020, our commissioner said in his remarks, I want to welcome everyone to your governmental center because I'd be willing to bet 9 out of 10 of you have never been here before. My students, my children, my community are not represented by this man. I am asking for a favorable report. Please give us the opportunity to fairly elect someone who will be an advocate for our community. Thank you for your time.
Thank you. One more, we have Joanne Anton. Ms. Antoine, you there? I know she's probably scrambling with other bills, so let me just go to the next person, and if she hops in, I'll go back to her. We'll take Miss McKenzie.
Hi, good afternoon. How is everyone? Thank you, Mr. Vice Chair. Thank you to the Ways and Means Committee. My name is Angasa Echile McKenzie. and I am representing Southern Marylanders for Racial Equality. So we work in Charles, Calvert, and St. Mary's counties. All three of them are impacted by this bill. And I just heard, why not just make this for St. Mary's County? And it irks me when I hear people ask the question, why not just you? Why not just fix your county and leave the rest of us alone? Well, because we believe in representative government across the board. This is America, and people's voices should not be tamped down by the majority who live in other parts of their counties. Yes, there are racial inequities created by the current system we have, as you've heard, and as you will continue to hear. Many Black voters in many counties just don't have representation in their county governments. Yes, the current system allows one party or the other to hold a vice grip on power and overlook the needs of certain communities. There's pockets of voters all over our state whose interests are simply being ignored, and not just along racial lines. This is also a socioeconomic issue, which is why I also support Delegate Crosby's other bill regarding polling locations along transportation routes. But in my county of Charles, we still have food deserts, commercial dead zones where there's no stores, no jobs, limited recreational opportunities, a scant arts community, scarce amounts of affordable housing, and a crumbling infrastructure. We have areas in my county, Charles County, where there's limited internet access during a pandemic. People with outdated plumbing, well and septic access, just basic things. But yet commerce is built up at a dizzying pace in certain population centers. Why? Why has Maryland continued to be a state with haves and have-nots? Well, it's because county commissioners rely on the will of the countywide majority to hold on to power, instead of looking closely at their individual districts to find solutions to those problems, to lift up those constituencies. And within each county, we have diverse needs, urban needs, suburban needs, and rural needs. All these voices have to be heard. If this bill somehow strikes you as anything other than critically necessary, then check yourself. Tell your county commissioners to get out there and earn the votes, put in the work in their districts. And people tend to turn out to vote for people who they think can make a change in their life. Thank you all for having me.
Thank you. Any questions? Delegate Buckle.
Thank you, Mr. Vice Chair. And I have a question for Ms. McKenzie. I appreciate your comments. You're from Charles County, is that correct? I'm sorry, I can't hear you.
Yes,
Okay.
I work in Charles, but I live in Charles, but I work on behalf of residents in Charles, Calvert, and St. Mary's.
Okay, but Charles County, I'm just trying to get this straight. Charles County has the same system for county commissioner elections by district, but you have to be still elected. You count the votes from countywide as St. Mary's. Is that your understanding?
Yes.
Is there any indication that somehow that's created a problem of racial discrimination in Charles County? What's the racial makeup of the Charles County commissioners?
I know where you're going with that. What I'm saying to you is Black people happen to be the majority in this county, but it's not the case in other counties. So
okay,
I know where you're going.
Okay, so in Charles County, it doesn't seem to be a problem. And the question that I would ask is, in order to get something passed in any county, you don't just pass something with one commissioner. If one commissioner was elected from, say, Lexington Park, the Delegate Crosby has talked about, and others, in order to get something passed in St. Mary's to fund something for Lexington Park, for example, they would still have to get the votes of the majority of the rest of the county council or the county commission, right?
Correct.
So just having that one person from that one particularized district, if they were not in sync with the majority of the rest of the county's commissioners, that wouldn't necessarily mean that all of a sudden more resources would be directed to that district, would it?
Well, no, nothing in government is automatic, but as you know, their issues aren't even being brought to the table. They don't have a voice at all. So if you never hear about it, how could you even vote on it?
Well, then my final question is, do you think that my county and many counties that have county commissioners, we don't elect county commissioners by district at all. They're elected countywide. What you've stated today seems to suggest that you would think that that's unconstitutional because somehow it would discriminate against whether it's a minority political group in a county or whether it's a minority ethnic or racial group, whatever it may be. Do you think that all counties would have to go to by district county commissioner or county council voting in order to be constitutional?
I would think that would be fair. That's what's fair. And that voting rights section 2, that's basically what it's saying. everybody needs a voice in government. It's a representative government. And so if it's a county-wide vote, there are swaths of the county that will not be heard, period.
Thank you.
Mm-hmm.
Thank you. Any other questions? Seeing none, we'll move on to the next panel. Next panel we'll have is Ms. Joanne Antoine back on? No? All right. Well, we will not be coming back to Ms. Joanne. The next folks we'll have is Ms. Caroline King and Ms. Beth Huffingel.
Thank you. Madam Chair, Mr. Vice Chair, and members of the committee. I'm testifying as a member of the St. Mary's County Democratic Central Committee. St. Mary's has only one Democrat representing us at the state or county level. Republicans have been successful in recent elections, and that's okay. It's the will of the people based on our current election system. But now that Republicans are in power across the board, they don't want to lose it. I believe that's why they're opposed to this bill. Our 5 white Republican commissioners know that they may lose a seat or 2. Never mind that voting by district is what's done at the state and federal levels, or that it would make it easier for Republican commissioners to campaign in and represent their own districts. It seems Republicans in St. Mary's don't want to give Democrats a fair shot. They oppose more access to early voting. They oppose mail-in voting. They recently removed several prominent Democrats from county boards and commissions. And when citizens requested that the county redistricting board be fair and balanced, one commissioner stated he was against equal political representation, and another suggested we look at gerrymandering at the state and federal level instead. The county redistricting board will draw lines for the next 10 years. On February 2nd, the commissioners voted to delay appointments to the board until after they receive census data. One commissioner stated, "We have to figure out what happens in the legislature this year in case there's any impacts on voting districts and the way people vote," end quote. Why should this bill affect the composition of the redistricting board? At their January 26th meeting, the commissioners laughed about this bill, asking why it was necessary, with one stating that minorities don't need help in getting elected. He said, "I think if you want to succeed, you can," end quote. Last year in St. Mary's County Commissioner District 4, Joe Biden won more votes than Donald Trump. In District 1, he very
Yeah.
St. Mary's
Where's
citizens.
the little blinker? Hey, Mr. Wilson, can you mute yourself? Thank you. And if anyone else, can you mute yourself? If you do not mute yourself, we're gonna have to remove you from the room. Thank you. Continue.
Okay, thank you. In Commissioner District 4, Joe Biden won more votes than Donald Trump. In District 1, he very nearly won. St. Mary's citizens are not getting the representation they deserve at the county commissioner level, and HB 655 would fix that. I am asking for a favorable report on this bill. Thank you.
Thank you. Ms. Beth Huffingel?
Huffnagel. Yes.
Huffnagel. I was trying to get it right. I apologize.
Not a problem. It's been that way for 67 years, so no difference. Good afternoon, Madam Chair, Mr. Vice Chair, and delegates. My name is Beth Huffnagel, and I'm speaking for the League of Women Voters of Maryland in support of House Bill 655. The president of the League of Women Voters of Calvert is also in support and has been advocating for this bill for some time. This is my first testimony ever to the Maryland General Assembly, and I'm proud that it's in support of such an important bill. The League of Women Voters supports standards that not only protect the right of all citizens to vote, but also encourage all citizens to vote. To that end, we support standards that promote fair and effective representation at all levels of government with maximum opportunity for public participation. As the law currently stands, 5 Maryland counties are divided into districts, yet the district commissioners are elected at large. This can and has resulted in voters being represented by a commissioner who was elected by a minority of voters in that particular district. This is unfair, ineffective representation, and discourages voter engagement, both in the voting process and with their commissioner. In 1985, a similar situation in Dorchester County was challenged to the federal courts as a violation of the Voting Rights Act and forced a change to the Maryland Constitution. The text on the Hurlock historical marker says, "Lest we forget, 1851, the Maryland Constitution was written requiring voting at large to assure control of minorities," unquote. Another lawsuit in 1992 showed another judge's concern for, quote, "effective political representation," unquote, in Dorchester County. There appears to be an ongoing pattern of discrimination in the rural counties of Maryland that needs to be addressed by legislation. We're aware of the growing apathy or civil unrest of voters because they believe that the system is rigged and that their vote will not matter. We believe that requiring that the voters in a particular district be represented by a district commissioner elected by a plurality of the voters in that district would help to restore the faith of voters in their elected officials. We urge a favorable report on House Bill 655. Thank you.
Thank you. Next, we'll have Charlene Poulios. Ms. Poulios? No? Okay. We'll take Kara.
Mr. Chair, she's on. She just can't get off mute.
She can't get off mute. Ms.
I've
Poulios?
got it. There we go. You hear me now?
I can hear you now. Go ahead.
All right. Madam Chair, Mr. Vice Chair, and members of the House Ways and Means Committee. I'm Charlene Poulios, President of the Garrett County Democratic Club. And I want to thank you for letting me testify before your committee in support of Maryland House Bill 655. I'm from Garrett County, where our television comes from Pittsburgh, much of our healthcare comes from Morgantown, and the political attitude comes from the last century. The at-large system in our county has facilitated the exclusion of one gender, women, and one political party, Democrats, from the process. This single party domination at the commissioner level has led to a decrease in population, continued investment in industrial parks that are not needed or well occupied, and a retreat to tribalism as demonstrated by the recent designation of Garrett County as a Second Amendment preservation county. This legislation will be very helpful to the voters in Garrett County, where there has not been a Democrat or a woman on the county commission in more than 25 years, quarter of a century. Democrats are a minority in countywide, but they deserve a chance. Women are a majority in the county and they deserve a seat at the table. We are very eager to join the rest of Maryland by having access to Maryland TV, a more progressive view towards governmental administration, and the abolition of at-large voting for county commission. Madam Chair, the Democrats of Garrett County support this legislation, and we are asking for a favorable report from the Ways and Means Committee. Thank you.
Thank you. Next, we'll have Kara Dudley.
Madam Chair, Mr. Vice Chair, and members of the House Ways and Means Committee. My name is Kara Dudley, and I live in District 27C in Calvert County. In our county, we have 3 district-specific commissioners, along with 2 commissioners at large who represent Calvert residents. Unfortunately, not all residents are getting fair and equal representation, as the entire county votes for all 5 commissioners. The decision of who represents residents within a district should be solely in the hands of those residents, not folks who live outside the district and whose priorities are guided by outside needs. This system not only disempowers voters, but it discourages qualified candidates from running, which does a disservice to us all. I firmly believe that all Calvert County residents deserve a voice in our local government and a seat at the table. Currently, that is not the case, but we have the opportunity to right this wrong and ensure the way we choose our local officials aligns with the spirit of the Voting Rights Act, Section 2. I'm asking for a favorable report for HB 655. Thank you for your time and consideration.
Thank you. We'll take any questions now if anyone has any questions. Delegate Buckle, your hand is still up. All right, I see no questions. Let's move on. Thank you everyone for your testimony.
It's that hand. It's just my hand. I'm sorry about that. It keeps going.
It's all good, man. It's all good. Thank you. All right, we'll take the next few speakers. We'll have Daryl Hinman, Rose Frederick, and Marcia Greenberg. Daryl Hinman is first.
Hello, good afternoon, everyone. I want to say thank you to Madam Chair, the Vice Chair, and all the members. My name is Daryl Hinman, and I'm the owner and head coach of the Knowledge Boxing Center, located right on Great Mills Road in Lexington Park, Maryland. At Knowledge Boxing, we help everyday citizens conquer anxiety, obesity, low self-esteem, depression, and we empower them. We also teach high-performing athletes how to compete and win amateur and professional fights. Now, there are two ways to get a fight, and I'm gonna set up an analogy here. There's two ways to win a fight. You can knock your opponent out, or you can win a decision that's rendered by 3 judges who sit ringside. The judges are present, attentive to the action, fully aware and fully immersed in the environment and the culture of the sport. They have a close connection and understanding of the boxing world. The decisions they make have a direct impact on everyone involved. Most importantly, they have a direct influence on who wins and who loses and all the benefits and consequences that come along with winning and losing. Now, imagine you are a boxer and the judges that have direct influence on your fate were not sitting ringside during your fight. They were not in the first row seats. They were not in the nosebleed seats. They weren't even in the arena that you were fighting in. They were 30 miles away from the action, yet still played a significant role in your success. And that's why I support this bill, because just like fighters, the citizens of St. Mary's County, particularly of Lexington Park, need judges or politicians that are in the arena, present, accountable, and paying close attention to the action. They need politicians who are intimately familiar with the environment, culture, and challenges offered by that particular area so the citizens can have a fair shake at being successful. And this is not a knock on the current commissioners, it's just logical and what makes sense. This bill will allow the people of a particular area, specifically Lexington Park, to pick a commissioner who they feel best relates to their experiences, will best serve their needs, and will give them the greatest chance to win the fight of life. It would allow voters to pick politicians that are closest to the action, that relate to the culture, and have an intimate understanding of what's going on and what needs to be done in order to ensure the success of the community. We ask for favorable support of this bill. Thank you.
Thank you, sir. Ms. Rose Frederick.
Good afternoon, Madam Chair, Mr. Vice President, Mr. Vice Chair, and members of the House and members of the House and Means Committee. Thank you. The current St. Mary's County election system for county commissioners, as you've heard and you're going to continue to hear, it silences individuals' voices. It silences those that want to make a difference in the county, and those of the majority party, they have a voice. This is undemocratic, and it leaves voters unrepresented in the local government. When commissioners obtain votes from the whole county, parts of the county are neglected. The current system violates the spirit of the Voting Rights Act. Primarily, it challenges our local communities. Voters in St. Mary's County, Oakville District 3, Lexington Park, District 4 are underrepresented because the elected commissioners are not concerned with the districts they are elected. But they are concerned with the county as a whole. If officials are elected to represent their districts and not their entire county, it would make for a complete representation of the county and district. We need for them to belong to the districts in order for it to work. Districts' needs, experiences, and voices would be heard, of which the current system is entire system is not being heard. an entire county is preventing from having their needs heard. I ran for county commissioner, and because of the current flawed system of being elected by the entire county, I lost the election. My district is now underrepresented because the elected commissioner is interested in the county as a whole and not the district he represents. The flawed system. You can change the flawed system now. And I ask in closing for a favorable report to this request. Thank you.
Okay, thank you, Ms. Frederick. And for anyone else speaking, we just want to make sure you turn on your video when you are speaking. Ms. Marcia Greenberg.
Thank you very much. Madam Chair, Mr. Vice Chair, and members of the House Ways and Means Committee. My name is Marcia Greenberg, and I live in Lexington Park in St. Mary's County. I'm speaking in support of HB 655. In America, we expect elected officials to be chosen by the voters they represent. In St. Mary's, this applies to our federal and state representatives, but not to our local officials. Rather than being elected by voters in districts they represent, commissioners are elected by voters countywide. Note that if this system were applied at the federal level, Maryland senators would be elected by voters across the country. This system is problematic. It prevents district residents from determining who represents them, and it causes commissioners representing districts to court support countywide. But there's another issue. This system works against localized projects, and I offer an illustration. For several years, residents in the southern part of St. Mary's have advocated for a community center to meet local needs, including indoor spaces for youth activities, programming to support young people's educational and employment success, and community space to foster relationships among military, retirees, and locals, and across racial and generational divisions. We have gathered petitions and data. We have built partnerships. We have disseminated information. But because of the center's purposes, the benefits would be particularly local. By definition, it is localized, which unfortunately generates a conflict. Within our current system, a commissioner whose district's voters passionately advocate for a local project finds it necessary to justify such a project to voters countywide. Instead, commissioners should be focused on and fully accountable to the residents of their districts. In closing, I urge this committee to issue a favorable report on HB 655. And I thank you very much.
Thank you. We'll take next witness, Roderick Lewis. Excuse me.
Good afternoon, Madam Chairwoman and Vice Chair and members of this committee. My name is Roderick Lewis. I'm one of Delegate Brian Crosby's constituents, and relocating to St. Mary's County in 2013 to attend college. I've been working and organizing on a number of important issues to many lifelong Lexington Park residents. Through this work, I've quickly realized that the Lexington Park community has often gone unheard. And to my surprise, doing some initial research before the Delegate Crosby took office, I learned that my commissioner at the time, representing District 4, was not directly elected by the district and not responsible directly by the voters of District 4. In fact, he was elected countywide. And that came to me as a surprise. I understand that there's typically a president of the board or a president of a county commission that is elected countywide to represent the interests of the county as a whole. But it came to my surprise that the individual districts in St. Mary's County was not set up that way, and that the entire voice of the county had their say in the matters of each individual district. Under this current system, county commissioners are elected by a plurality of the countywide vote. This system has resulted in a dilution of voting power for Lexington Park community members, a community that's incredibly diverse. House Bill 655 would correct this undemocratic system. The people should have the ability to effectively participate in the political system in which they belong to. And during a time when some state legislators are trying to create barriers to the ballot box, I think there's no better time to be champions of democracy. I urge the committee to assure a favorable report on House Bill 655. Thank you.
Thank you. Next, we'll have Ellen Cole.
Thank you. Madam Chair, Mr. Vice Chair, and members of the House Ways and Means Committee. My name is Ellen Cole. I'm an assistant professor of environmental studies at St. Mary's College in Maryland. I have my PhD in human geography with a focus on policies and conduct of local governments outside major urban areas and how structural racism impacts local experiences. I'm speaking today in favor of House Bill 655 as an expert in my field and as a faculty member, not a representative of St. Mary's College in Maryland. In my written testimony, I summarize the history of voter disenfranchisement, demonstrating how at-large voting represents a second-generation barrier to voting, or what some have called Jim Crow 2.0. At-large voting, along with voter identification laws, racial gerrymandering, and discriminatory annex, are a direct response to the end of the Jim Crow era, when overt techniques for voter disenfranchisement gave way to indirect structural barriers. Simply put, our democracy and community is strengthened by diversity. In my written testimony, I show the discriminatory impact of at-large voting. For example, in St. Mary's County, where 74% of the population is white, 100% of the current county commissioners are white, and there's only been one Black county commissioner. The importance of diverse and descriptive representation at the local level cannot be underestimated. District voting does not prescribe an outcome, but creates opportunities to elect someone voters believe will best represent their district's needs. Legislatures must counter second-generation forms of voter disenfranchisement and histories of racial discrimination by erasing vestiges of structural racism. Requiring county commissioners to be elected by their district constituents rather than at large is a structural step towards allowing the voices of Black, Indigenous, people of color to be heard through local representation. That step towards a more perfect union is why I'm asking for a favorable report on House Bill 655. Thank you.
Thank you. Any questions of the last few speakers? Seeing none, thank you all very much. We'll go on to the next few speakers. Paula Cox.
Good afternoon, Madam Chair, Mr. Vice Chair, members of the House and Means Committee. Thank you for your time and attention to this important matter. My name is Paula Cox, and I am the director of an after-school program in the Colony Square community located in Lexington Park, Maryland. I am here because I have the hearts and interests of the children and families I know and work with in mind. As you know, our system is built to work with and for the people. Public servants are voted into place and embody roles so they can speak and act on behalf of the people they serve. Unfortunately, this is not happening in our community. The current system by which county commissioners are elected in St. Mary's County is silencing the voices and votes of people who should be allowed to speak. Often this happens, but it must not be so. Before opening the after-school program in 2018, I worked diligently with those in the community to empower their voices by walking alongside them to hear both the assets and needs of the community. From the listening, the after-school program was born. If I had not taken the time to know and hear from the families that lived in the community and been invited in to help to be a solution in their community, I could have done great harm. I see this happening with our commissioners. They are quick to show up for a photo op once a year during National Night Out, yet they fail to see Colony Square and other neighborhoods like it in Lexington Park as anything other than a problem to deal with. Seeing constituents as a problem to be managed rather than valuable resources that are part of the growth and opportunity that is needed for a thriving community is the reason we need change. Our community needs a commissioner who will seek to do what's best for its interests, public servants who listen and want to make a difference as they serve and help. This person should be voted on by the people from their own district, and they should work hard to represent the people of their district, fighting for the rights and needs of all people, especially people who are not represented. Thank you so much for hearing my testimony. I'm asking for a favorable report.
Thank you. For the members, I'm going to continue with all of the favorables, and then I'll ask if there's any questions at the end. We have William Hall and Janice Walter. William Hall first. Okay, in 3, 2, 1.
Hello.
Oh, there we go. Okay, right on time, man. Go ahead, Mr. Hall. Go ahead.
All right, thank you. Thank you, Madam Chair, Mr. Vice Chair, honorable members of the committee. My name is William Hall, President of St. Mary's branch of the NAACP. The St. Mary's NAACP and the St. Mary's branch of the NAACP and the Maryland State Conference strongly encourage a favorable committee vote on HB 0655. This bill is about improving democracy, period. For decades, several counties in Maryland have operated under an at-large voting system for the county commissioner election. If a district does not have an exclusive right to its does not have exclusive rights to the choice of its representation, something is wrong with that system, and the voters in that system are not being properly served or represented. This dilution of voting power is anti-democratic and runs counter to the spirit of the Voting Rights Act. The current system silences voices of voters in specific districts, replacing their votes with those of the majority of the county, potentially leaving voters with local representation elected by others. This bill seeks to rectify this injustice happening in St. Mary's County and other counties around the state. It requires the candidates for Board of County Commissioners to win a plurality of votes in the district they hope to represent. Every state and federally elected official in Maryland has to win in the district in which they are running. The people residing in the rural counties of Maryland deserve the right to have that same rule apply to their county elections. In St. Mary's County, specifically, this results in disenfranchisement of a large number of our minority voters. Votes from the rest of the county dilute the votes from our community. It's unacceptable. Section 2 of the Voting Rights Act of 1965 prohibits voting practices or procedures that result in discrimination or the abridgment of the right of any citizen to vote. Most challenges that fall under this section involve at-large voting schemes. And our current system mirrors systems that have been changed because they violate the Voting Rights Act. We stand in solidarity with the NAACP branches of the counties impacted by similar systems and with the Maryland State Conference of the NAACP, and we are calling for reform. Those who champion democracy and civil rights must do everything they can to strengthen it. This bill is one way the Maryland General Assembly can strengthen democracy in our state. For these reasons, the St. Mary's branch and the Maryland State Conference of the NAACP urge the committee to issue a favorable report for House Bill 0655. We deserve the right to select the people that represent us at all levels. Help us make that a reality. Thank you.
Thank you. Janice Walter.
Good afternoon, Mr. Vice Chair and Madam Chair. I'm Janice Talbot Walthour, and I'm here to support House Bill 655. And you've heard many of the speakers talk about what it would mean, and though a change to per district would mean that winning the plurality of votes from his or her district would give more credence of a voice to the voters in that district. It doesn't prohibit the commissioner from advocating for other citizens in other districts. But why assign districts if voters in other districts can garner a plurality of votes for the candidate representing your district. This dilutes voters' voices, and is not representative government. Let's not hide behind the veil of ignorance, meaning that, well, it wasn't done to disenfranchise voters, and it's not done like that. I mean, there might be many in other counties, and it's working for, but presently what the situation we're in across the country, where many of our legislators do know what rules will benefit them and their party and their interests, and they want to keep them. They want to keep the status quo and the power. A change in the process could positively impact many people in Lexington Park and Great Mills, in the voting areas that we talked about. The 4th Commissioner District is large. It's the majority of the people live there. And so if the majority of the people live there, the affordable housing is going to be there. Social services has been sent. They send all their people to this area. As a matter of fact, we probably need more than one commissioner, because it's just packed. And then they've added another area to this district. And the demographics there are so that the people in this area really do need more support. Yet the commissioners representing these demographics can garner support from citizens outside of the district and get the right to represent people in districts like this, where perhaps he or she did not get the most votes. This leads to a vast majority of disenfranchised voters, as you've heard, with people of color and low socioeconomic levels. It creates a conundrum of whose interests are being served. Voters from other districts in higher numbers, or voters in need in the commissioner's home district, whose interests are really being served. Though elected to serve the entire county when imposed to sorely needed resources for communities not in their assigned districts, then the rationale becomes, well, the people in my district are opposed to it. So you can have it one way or the other. What way do you want? And as you heard Ms. Cole say, Dr. Cole say, there has not been a commissioner of color since the 1990s in St. Mary's County. And so maybe this new process could help energize voters if they understood that they were truly being represented. Thank you, and please support HB 655.
Thank you. Next, we'll have Rick Pierik.
Yes. Hi. Thank you, Madam Chair and Mr. Vice Chair and committee members. My name is Rick Pierik, and I'm an attorney and proud resident of Chesapeake Beach in Calvert County. Today, I'm testifying on my own behalf, but I am a member of the Calvert County Democratic Central Committee. Today, I'm here asking for your support towards House Bill 655 regarding commissioner voting districts. Calvert County is one of Maryland's smallest counties. Its geography is long and narrow. It is flanked by the Patuxent River on one side and Chesapeake Bay on the other. The Calvert County is comprised of 3 commissioner voting districts. Each district is unique and has different demographics, needs, and wants. In addition to our district commissioners, Calvert voters also elect 2 at-large commissioners, which I point out would remain the same after the passage of House Bill 655. Under our current voting system, a commissioner candidate in District 3 can win the overwhelming majority of votes within his or her own district, only to lose based on votes from the other 2 districts. The effect of this system is that citizens such as myself are disenfranchised and lack the ability to hold our elected officials accountable for their actions or lack thereof. Under the current scheme, all 5 commissioners are elected countywide. These countywide campaigns are expensive and discourages candidates of less means from running from office. As a result, our Board of County Commissioners are all older white males, despite the county having nearly 25% of its population be something other than white. There is no diversity of thought, opinion, or perspective. Furthermore, as an attorney, I can tell this committee that under the current election system, it is certainly a violation of the Voting Rights Act of 1965 specifically Section 2, which prohibits any voting practice that has a discriminatory effect, not, as pointed out before, discriminatory intent. That is, the commissioners don't have to want to discriminate, but rather that the law and the way it's set up has that effect of discriminating, which certainly I would opine it does. Whether or not the practice was enacted or administered for the purpose of discriminating. In both Calvert County and St. Mary's County, minorities tend to be clustered within certain districts. The effect of this countywide district is nothing more than silencing their voices, diluting their votes, and making sure that their specific needs are not addressed. In summary, I ask you all for a favorable report of House Bill 655, given the negative impact of current system, particularly to smaller jurisdictions, which this bill seeks to address. Thank you all for your time.
Thank you. Jeanette Flame. Or Flame. Ms. Jeanette. Okay, we're gonna move on to Roderick McClanahan. And then I'll take questions after. All right, seeing either one of those speakers, let's go to our questions. Delegate Patterson.
Thank you, Mr. Vice Chair, and thank you for the testimony I've heard. This question is for Dr. Walthour. Thank you very much for your testimony. And in terms of the history of St. Mary's County, I know the commissioner you're alluding to was Commissioner John Lancaster. My question is, with the absence of HB 655, has that dissuaded eligible and qualified minority candidates from seeking the commissioner race? I know that they know it's an unattainable position, but has it discouraged people from really seeking this position?
Well, I think there have been people, I think Rose Frederick is on the call here and who has tried to get in the game and has not as a woman and as an African-American. My sister ran for commissioner. It does not, but I think that it does. What has happened is that, you know, after a while, it's like the powers that be have control. And if I'm running for commissioner and I want to win, and someone is running against me that has pockets of people in every district and they're in power, I don't foresee a way forward, then often people get discouraged and they don't.
Absolutely. My whole purpose for the questions is like that there are qualified individuals who have sought this position, but yet they were overwhelmed because of the numbers and the rules that were stacked against them. Thank you very much.
Thank you.
Excuse me.
No, sir. No, sir. I'm gonna ask Miss Frederick. Did you have anything? Did you have anything to add to that since your name was called in this? You have anything to say?
Yes, I did. And I agree with Dr. Walther that there are particular pockets. I can attest to winning in an area, but because it's countywide and 3 specific pockets have voted against me, I did not win in my district. So there is a difference in the pockets of person. So if you're in your district and you are running, then yes, you can win. But if it's countywide, there is no way because of those specific pockets. Now, I believe that no, there has not been other than Ms. Mathis. There has not been any other since Mr. Lancaster. And it's because of that reason. And when I was running, I even had the comments given to me from people of color that said, I will back you, but you know you're not going to win because of the community as a whole.
Thank you. Mr. Hall, I want to give you an opportunity to answer if you like. Just a quick 30 seconds, sir. Go ahead.
Roger that. I believe Mary Washington ran as well. Then, but I know that it's come up in discussion, especially with a lot of younger voters, but a lot of potential candidates that have been younger, but they've been discouraged by the current system. And so I've heard people say that I won't do it because I know that I can't win in such a system. So I think we said that there weren't that many people that were discouraged initially, but I wanted to make sure that I know of several qualified members.
Thank you very much. Let's go to Delegate Hornberger for a question.
Thank you, Mr. Vice Chair. And just some clarifying questions here because that was a lot of testimony and I'll make sure that I'm understanding the fiscal note. So you are currently at large for 3 council seats and you want to move to Council-matic for those 3 council seats. Is that a fair synopsis of the bill?
Delegate Crosby, you want to answer
that? No, we have county commission form of government. We will keep county commission form of government. In fact, all 5 that this would impact are going to keep the government. What we're trying to say is if you have whatever type of government you have, if you vote where you have geographical representation by district, the votes must come from that district. So it sets it up like other counties on the Eastern Shore. That's the central premise of the bill, just like Somerset or Dorchester are the easiest I can give.
Okay, so I think that's referred to as Council-matic, right? In other words, you have to have residency and only people that are in that district can vote for you.
Or districts.
I apologize. I didn't realize that was the term. Then yes.
Okay. So who would draw these lines when the next census comes up, which will be this next election?
It will still be the local boards.
It'll still be the local boards. Okay. So in looking at some of the demographics, you're at around 112,000 people. The voter registration is roughly split. I think you're at 26,000 Democrats and 30,000 Republicans with about 16,000 independents up for grabs. My question to you is, with all that heartfelt testimony, moving in this direction will not necessarily elect a candidate of a particular party or a particular background. Why wouldn't you look more at going to a charter county, considering that there's 2 other counties in Maryland that have less population that have already moved in that direction?
I would have no problem if St. Mary's County went to a charter county, if that's what they would put that on the, on a ballot and they can vote. But we did vote for Code Home Rule, or excuse me, we voted against Code Home Rule twice already at the county level. But that's really irrelevant. I guess the better question would be, here we are as state delegates all representing districts, and we don't vote as a whole. And I could tell you that coming from a competitive district, if we voted by the entire state of Maryland, all I had to do was live in 29B, things would be a little bit easier. But every day I got to get up and I realize that I have to earn, my keep, so to speak, for people of St. Mary's County. And I know that. And so I go up there, and while I still have a broader perspective for Marylanders as a whole, I am concerned about, St. Mary's County's well-being, and I advocate for that at the state level.
Okay. Thank you, Mr. Vice Chair.
Thank you. Any other questions? Okay, now we'll move on to the unfavorables. First unfavorable we have is Randy Guy, and then who's a commissioner of St. Mary's County, and then James Moran with Queen Anne's County.
Thank you, Madam Chair and members of the committee. I am Randy Guy, President Commissioner of St. Mary's County. With me is Eric Colvin, Commissioner of St. Mary's County District 1. We are both Republicans. Additionally, with me, our former Commissioner of St. Mary's County, Thomas Manley, who for 12 years represented District 2, and Daniel Relly, who for 12 years represented District 4. They are both Democrats. As previously agreed, I would be the only providing testimony today. Am I on?
Yes, sir. We can hear you. We can hear you.
Okay, I will be the only one providing. It is important to note that we appear today as representatives of a cross-section of political ideals, jurisdictions, and current past commissioners are for St. Mary's County. We are all here in bipartisan, multi-jurisdictional, unanimous opposition to House Bill 655, as proposed by Delegate Crosby. The proposed bill seeks to unilaterally undermine the will of the people of St. Mary's County by insisting upon mandating how we choose and vote for local officials. Historically, the people of St. Mary's County have been active and local in making their choices for local representation known. These choices include electing commissioners who can individually and collectively represent the entire county. Each commissioner responds to, advocates for, and serves not only their district, but every St. Mary's County constituent. There are no economic, geographic, or legal legislative lines drawn. We all work to serve all of the county regardless of what district we represent. Our system is not broken, and we do not need to be told how to restructure it. Dan Ridley ran unopposed in his last term as commissioner. Commissioner Tom Morgan, currently representing the 4th Commissioner, has been unopposed the last 2 elections. Surely, if one were disenfranchised, there were no competing candidates to support this. St. Mary's County voters have and continue to speak. They know who they want to represent them and how they want to vote for them. Our residents have not asked to change the way we vote. Recently, we attempted to change our form of government from commissioner to code home rule. The people voted no. We, the Commission of St. Mary's County, have a clear and open path to letting voters tell us what they feel is important in St. Mary's County, and we have public hearings, public forums, and a process of open and transparent government. When the pandemic hit and public gathering sizes reduced, St. Mary's County rapidly pivoted to provide virtual meetings that are accessible to any and all residents of St. Mary's County. The county government could continue to operate. St. Mary's County residents could continue to participate in county government safely but actively. The Maryland Association of Counties and the Maryland Rural County Coalition stand with us in opposition to this proposed bill because it is not a good or effective way to mandate how St. Mary's County or any other counties vote. In closing, let me restate that we are strongly opposed to House Bill 655 and are respectfully requesting that it be defeated. Thank you.
Thank you. Let's take a couple more folks on there, and then we'll take some questions. James Morin. Okay. Stephen Wilson.
Here I am. Sorry about that. Madam Chair, Vice Chair, my name is Jim Moran. I am the at-large County Commissioner for Queen Anne's County. I'm here today in opposition of House Bill 655, and I want to tell you a little bit about Queen Anne's County. Approximately 4 years ago, the 2016 election, I lobbied our delegate and our senator for a straw poll on as a referendum at the 2016 election for just what you're asking about here, voting by district. At that time, I was in favor of voting by district. We got it put on the ballot. All across the county, there was a vote, and the vote came back 46 for and 54 against, changing the way we elect our commissioners. So with that being said, I supported the will of the people of Queen Anne's County, and we still do to this day. We don't have any problems in Queen Anne's County. I listened to testimony all day long of what's going on in St. Mary's County, and I feel for you, but you know, again, one fix doesn't work across the entire state. We've learned it from COVID. We've learned it from education. You know, each jurisdiction deserves the right to elect their officials in a fair and honest way, and I think in Queen Anne's County we do that. So, you know, we are here in opposition, and I'll be happy to answer any questions later on. Thank you.
Thank you, sir. We'll take next Stephen Wilson. And then Kevin Canali. Mr. Wilson. Okay, Mr. Canali, are you on?
Yes, thank you, Mr. Vice Chair and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in opposition to House Bill 655. You have my written testimony, but I would like to make a few points. So counties are concerned that this is a one-size-fits-all approach and that it would infringe on local autonomy and flexibility in local governance. The method and structure of county elections are matters reasonably left to those governed. And currently that authority is properly vested in county governing bodies, regardless of their local structure of governance. I'm not here to argue the merits of any particular voting method, but in American jurisprudence, the proper venue to remedy any defect in district drawing or representative structures is the courts. It is not a superior political body. You've heard mention of Dorchester County in the 80s. In fact, in 1986, Maryland voters approved a constitutional amendment to repeal the requirement that county commissioners and council members be elected at large by the entire county. Instead, the measure properly allowed county governments to determine whether commissioners and council members should be elected by districts, the entire county, or a combination of these methods. And it was the courts who detected that problem in the 1980s. It was the courts who mandated a solution, and it was the courts that triggered an eventual constitutional amendment that brought us the system that we have today. Local decision makers are elected to serve public needs, and their actions are subject to broad stakeholder input. This bill would infringe on local decision-making, and the bottom line is that the courts are the proper venue to redress these grievances. And with that, we've respectfully asked for an unfavorable report on House Bill 655.
Thank you. Thank you, Mr. Canali. And I believe that was the last speaker of the day. Any questions of the previous speakers? Seeing none, thank you very much to the members. That concludes the public hearing for House Bill 655. And that concludes the hearing for today. And I want to just thank everybody on both sides of this issue for being here today. Thank you very much. And all the other bills as well. Anything for the good of the order for the committee? Delegate Wilkins.
Yes, Mr. Chair. How did you know? The election.
I just saw it. I saw it coming. I can read your mind.
The Election Law Subcommittee will meet immediately after floor on Thursday. So if everyone can please be in front of your computers after floor on Thursday so that we can work to vote out 2 bills. Thank you.
Awesome. Awesome. Okay. Any other comments from any other subcommittee chairs?
Local revenues, stay tuned.
Who is that speaking? Who is that?
The man.
Mr. Chairman, go ahead.
Yeah, I'm sorry, Mr. Chairman. Local revenues, stay tuned.
All right, cool. Anyone else? I'll also just add that I'm sure we're meeting tomorrow, but on Thursday, the Education Subcommittee meeting will happen on Thursday as well. We'll probably try to go before the Ways and Means hearing. So we'll keep you posted on that. Seeing no other comments.
And Mr. Vice Chair, I have returned, and I just want to remind everyone that in addition to our public hearing tomorrow, we do have a voting session on the Governor's Relief Act bill at 1 p.m. tomorrow.
Well, with that said, be on time tomorrow, and we'll see you then. Talk to you soon.